Lady, Madam Chair. It is not every day you are honored to be introduced by the former Chief Justice, whom I was petrified to practice before, and who once ordered for my appearance when I was out of the jurisdiction and my junior messed up before you. But still I take time with the pleasure of your audience, and since my lady mentioned 50 years, I would like us to congratulate her again. 50 years is a milestone at the bar. And if I'm not wrong, I think our senior most is 60 plus at the bar, which 62 at the bar. 62 at the bar. And while standing on the pleasures of their golden milestones in Ghana, I would like to also correct respectfully that I'm actually 23 at the bar. So that 19 was, I think it's an old, they pulled it from the internet, you know, I'm sure. Exactly. So I have to, before you start summoning me to General Legal Counsel, to explain when I was practicing my license. So indeed, I'm 23. But by the grace of God, thank you very much, the Honorable former Chief Justice, for those kind words. I can assure you from the outset of my presentation that I'm not going to speak for long, and for good reason. I think that this is actually the second time I'm speaking on this subject, very similar by way of the topic construction, in the same venue, the IEA. The last time I spoke on this subject, the theme was on the trusteeship of Ghanaians in our mineral rights. What trustee authority we have vested in our mineral rights, and who is therefore managing them on our behalf as the trustee. Article 257 of the Constitution, I'd like to start with that context, states clearly who owns the minerals of Ghana. And Article 257 is unmistakable in its choice of words and in its direction of responsibility. The choice of words says the minerals of Ghana are owned by the people of Ghana. Ghana own the minerals of Ghana, and the authority for the management of the minerals of Ghana are vested, or is vested, in the President of Ghana. There's a reason for that. I think our colonial history states one thing clearly, and that is the fact that Ghana became Ghana in the first place precisely because some foreigners identified that there were some minerals in Ghana, and through subterfuge, I don't think we can be diplomatic about that anymore, but through subterfuge, they took over the leadership of Ghana, and when they were leaving, they gave us a political establishment called Ghana. Before then, there was no Ghana. In that sense, if there was one reality that as a people we can commonly agree on, that reality is the fact that our country is blessed with natural resources, because the historical experience of colonialism is directly tied to the abundance of natural resources in our land. I think it is that colonial reality that explains why the Constitution chose to recognize clearly the fact that there are resources that are commonly owned by the Commonwealth, and that those resources would have to be managed for and on behalf of the people of Ghana by leadership. So it's not so complicated to recognize from the outset the fact that we have gold, water, timber, everything vested in our land, and those resources are to be managed for and on behalf of the people of Ghana by the President of Ghana. Again, it's not too difficult to appreciate. I'd like to acknowledge the entrance of the Honorable Minority Leader who has just joined us. Madam Chair, with permission, I proceed. It is, again, not too difficult to appreciate, therefore, in this context, the reason why the President is the one who's vested with authority. The reason is simple. The President is the one who subjects himself for elections before the people of Ghana. He tours this country seeking the vote of Ghanaians, and is elected. It is proper and fitting that a person in the personality and caliber of the President is the one who ought to be charged with a mandate to manage the mineral resources on behalf of the people of Ghana. Again, some people have complained about the structure of the Constitution, on how too many things are apparently vested in the President. And in this case, the minerals of Ghana. Why don't we vest it in Parliament, for example? The truth of the matter, as I argued the last time I spoke on this subject some time ago, is that Parliament, and I'm saying this on the back of the Minority Leader's entrance, but Parliament Parliament doesn't do well, not because it is Parliament, but because it's a collegiate body. Collegiate bodies do not do well managing things. And the reason is there's diffusion of responsibility. We can speak of Parliament as a group, but the truth of the matter is that it is a group that comprises 275 people. There's that diffusion of responsibility. Who do we really hold accountable? Is it the Speaker? The Speaker doesn't vote. It takes the political parties and the members of Parliament to vote. So it is easy to blame everyone, and in reality, no one. It is easier for us to hold a body like the President, who is one person, accountable for things. So if you look at the Constitution, it is only the executive which is actually vested in a person. The Parliament is vested in the corporate Parliament, the group. The judiciary is not vested in the Chief Justice. It is in the entire judiciary, headed by the Chief Justice. The President, under Article 58, is vested with executive authority as him alone. And that's why he can fire and appoint anybody he wants as a minister, and nobody can hold him accountable, so to speak. So in this sense, it makes sense why we have the President managing our resources. But as this presentation will show very shortly in my discussion, the fact that the President is vested with this authority is also partly to blame for the difficulty we have in the management of our natural resources. Because we expose the same President to the kinds of political pressures that Ghana goes through in a cyclical way. Every 4 years we have to go for elections, and then somehow Ghanaians are very good at creating a problem and then closing their eyes to the problem. A lot of the problems that we have, essentially, they are creatures of law. The law has created them. And somehow we don't seem to address the issue holistically. Once you have a president who has to subject himself to appointment every 4 years, and he's exposed to the political pressures of the moment, you would have to understand that these pressures tend to have a systemic effect. And the management of natural resources is a fundamental area of those political pressures, fundamental area that we have to look at moving forward. This therefore creates some of the challenges of what constitutes a natural resource versus the environment. Is natural resource just gold, as for some reason gold, diamond, and all these other resources, and somehow we have tended to treat others as less of resources? Today, as we deal with Galamsey, we tend to speak of the gold, but we don't tend to, as a natural resource, but we don't tend to speak of the water as a natural resource. What we have here is a clash of resources in which we have tended to prioritize some resources over others, in which we have tended to look at short-term gains as priorities as opposed to other long-term dangers that we are as it were, causing on the other resources which have not been treated with the same level of priority. So immediately we have scenarios of abuse and exploitation or violation. We have resources that are being abused in their exploitation. It's almost as if how you get to the resource is not important. Get to the resource. Where we sit might just have gold, and I'm just probably putting the IEA in danger. Because if it does have gold, I'm sure tomorrow you wake up and you come here, and then you see excavators, you see all kinds of things that are digging the IEA's premises. Not to mention, again, as I expose the minority leader, who, by the way, is a former student of St. Augustine's College. We are proud of him. So I'm happy to go against him on many occasions in my presentation today. But if only Parliament, one morning, MPs are going to Parliament, and then the premises of Parliament is barricaded, and we have the building itself, probably portions being pulled down because somebody says there's gold in there, and we have to get to the gold. What use is Parliament? What use is the building when it's sitting on gold, and we can just go for the gold? I think what we have on our hands is a case in which once we can identify the prevalence of resource in a particular place, we can go for the resource. No matter how we get to it, that is not important. The most important thing is we get to the resource. I advert our minds, colleague, to Article 257 again. There's a reason why it is vested in the President. Because the President is supposed to exercise judgment. So that if the President identifies that there's gold or diamond or bauxite or rare earth minerals or any other resource in a particular place, the President can exercise judgment by saying the location of the resource makes it untenable to go for the resource. We have to start getting to that point where we do a balancing of interest, where we do a balancing of priorities and come to a conclusion that there may be gold in there, but shall we go for the gold? Because it may be too costly to get to the gold. Ladies and gentlemen, the Honorable Chair, the issue has been worsened by politics, as I mentioned earlier. We've gotten to that point where, in our country, once we politicize anything, the matter is suddenly fair game. We can just discount it. And so once you put the name NDC or MPP on a particular subject, suddenly even acts of criminality are no more are no more issues of crime because we have politicized it. I think we've gotten to that point where the exploitation of natural resources and the wanton destruction of one resource. So I am not calling it the environment, I'm calling it resource, because the natural environment itself is a resource. And we're getting to that point where by politicizing one resource against the other, the destruction of one resource in the name of another becomes fair game. We have gotten to the point where Galamsey, which is the major problem that we have on our hands as a country, suddenly has gained the coloration of NDC or MPP. Once we call it the NDC or MPP, some criminals are NDC criminals, other criminals are MPP criminals. They are no more criminals. So the ones in government are protecting them. The ones out of government may be waiting to protect theirs. We have gotten to that point where criminals have understood the game. So fund the system, and the system will protect you. Unfortunately, the system may not be sustainable enough to hang around, to protect even those who may be expecting to be protected in the future. Environmentalists have said that the environment is a finite resource. Somehow we tend to think sometimes that, the atmosphere is always there. There'll be air all the time. Water bodies are abundant. We'll have water bodies all the time. I think recent publications have come to show clearly that even our sources of drinking water may be very quickly, in a very fast way, getting depleted. That if we are not careful as a country, sooner than later, we would have to import water. For those who may be following the African politics, you may know that Ethiopia and Egypt recently came close to going to war over the Nile. And the AU had to step in because of the lack of abundance, so to speak, of the Nile and the direction in which it flows. The truth of the matter is, it is about time that even as we think of a reform of our mining and minerals law, we should remember that water itself is part of that resource. Somehow, unfortunately, because our statutes have tended to treat water under different statutes, different set of laws. We have Water Resources Act and all. Because they've been treated under different set of laws, we don't think of water itself as a resource with that level of finiteness, and that sooner than later, we may not even have enough water around. I would argue that our other resources are finer than gold. They are finer than bauxite. They are finer than the resources that conventionally we think about when we think of these natural resources. And recently, I posted something somewhere about the King Midas story. Anybody who knows that story will know about the Greek mythology, in which there lived a king whose wish, when the gods asked him to make a wish, whatever you want, we'll give it to you. And his wish was, I want gold. Anything I touch should be gold. He didn't think very deeply about his request. And according to the myth, the gods gave him his request. And very soon, King Midas realized that even the food that was entering his mouth has become gold. Because he forgot that he requested that anything he touches should be gold. Now, the story went on that the gods advised him to go into a certain river and bathe. That would be the solution to his problem. Unfortunately, as soon as he touched the river became gold. So his story was simply unsolvable. His problem was unsolvable. We may be getting to a point with the Galamsey thing, when sooner than later we will realize that we can't eat gold. And that with all the money we may have made through Galamsey, the food on our table, as somebody said somewhere today, the ebunu that some people like, the contomere may just contain too much heavy metals. And I say before me, the Honorable Kokofu, who was at the EPA, perhaps I'm sure in discussions he'll tell us how many people he arrested during his period for Galamsey. But one of the key things that I would like to talk about today, and then we'll weave that into what our expectations about mineral rights, especially any reform is concerned, what we should look at, is the issue of stabilization. One of the key problems that people have had, and this is to the higher level of the mineral exploitation, I'm talking about the companies who do the right things, the companies who have the right contracts, they are properly structured and set up, their exploitation of gold and resources are sustainable, they do not indulge in the depletion and destruction of the natural environment and all that. These companies tend to be properly organized, so they don't have the environmental problem, often. But the problems they tend to have when it comes to natural resource exploitation, particularly in the context of the political economy of natural resource exploitation, is the issue of stabilization. Contract stabilization has to do with clauses that introduce provisions that essentially says that these provisions, I mean the provisions of the mining contracts, for example, shall not be changed willy-nilly, shall not be changed at will. Now there's a good reason for these, especially in developing countries where one government comes, another government goes, one government goes, another government comes, and the incoming government simply says, look, we were not the ones who negotiated this. We don't know anything about this. We have to renegotiate. And so suddenly, your lease concession has been, cut in half. Suddenly, the duration has been cut in half. Suddenly, the government has taken a portion of the shares. All these things. Stabilization contracts essentially freeze the opportunity of a country to change the contractual obligations or rights that are contained in the contract. So they are fundamentally good. They are not a bad thing, and they are not something that typically we should worry about. The reason why stabilization has come up for some discussion in recent times, or stabilization clauses have come up in recent times, has to do with the fact that it does appear as if many of the mining contracts that we have in Ghana are either poorly negotiated or suspiciously negotiated. Some of them contain next to nothing for the country. And so with stabilization, many of these contracts are locked in perhaps for the next 30 years, 40 years, for how long? And so whether we like it or not, because the contract says you can't renegotiate the terms, so to speak, as a people we are consigned to them. Which then introduces the question, who is negotiating on behalf of Ghana? I think it's one thing that often we don't pay attention to, especially as we do our politics. Because in our politics, we sort of compensate people who supported a political campaign. We compensate them with appointments. Again, this is something we can't dance around anymore. They are realities. People who supported a campaign or people who are members of the party tend to be appointed. And so very often the people who may be in positions may not necessarily be the best of brains that we have in Ghana. These are the ones who often will also lead some of the negotiations. And you see contracts, and then you start wondering who were our negotiators, who led Ghana's team, and who ultimately signed. But then the question will also be raised, ultimately went before Parliament. And then parliamentarians will say, well, we're asked to approve this under a certificate of emergency or a certificate of urgency. And many of them may approve without even having seen the contract. These are the realities of our constitutional governance. And therefore, if you find these interwoven in a systemic manner, there's only one conclusion. And that conclusion is value for money often is lost on us as a people. So stabilization is a red flag. It's one thing that any mining contract moving forward into the future would have to look at. Can we do away with stabilization? Maybe not. Because the mining contracts are going to demand that. They are not going to agree to sink in hundreds of millions of dollars sometimes, only for contracts that can be changed at will to be signed or executed. They will not agree to that. So there are realities. They will not agree to contracts that do not protect them in the medium to long term. But there can be ways of crafting the stabilization. There can be ways of looking at these things within the context of corruption, within the context of rent seeking. Our country has rent economy, and there are foreign investors who understand the game. The truth of the matter is that there are foreign investors who know Africa. There are some who know Africa but can't do much, especially those from America, because there's a law called the Foreign Corrupt Practices Act. So they are quite careful about that. But there are other foreign investors who don't have such restrictions. And when they come to town, they understand the dynamics. They know who to see. And if I can see one official and be able to, compensate the official, quote and unquote, not corrupt, but compensate the official in ways that would make the official happy and rich, and then be able to get a concession that would make me 100 times or 1,000,000 times richer, of course, I can do the calculations and do what I have to do. So the truth of the matter is, as we negotiate stabilizations, And as we put them in statutes, perhaps the time has come when we should look at stabilization in the context of a country that is riddled with corruption. A conversation, again, we can't be nice about, but we have to be honest about it. The Constitution then also contains the issue of the resource and the benefit. Now, the resource and the benefit issue is one constitutional factor that we'll have to look at moving forward into the future. The Constitution says, the resources of Ghana are owned by the people of Ghana, vested in the people of Ghana, to be managed per trusteeship by the president. So the president is the trustee. If the president is a trustee and if the people of Ghana own the resources, maybe, and I can see reform proposals that I think are good if we can ultimately get these through Parliament. The issue about the question of royalties versus beneficial ownership. So far, our ownership has been manifested in royalties. So somebody comes, sets up a company, he exploits the gold, and he agrees to give you a fraction of what he exploits per royalties. If you're lucky, you have 10%, and then the 90% is taken away outside the country. Other countries have shown the way. In the case of Botswana, which is the model that we all like, it is not royalties. The model is ownership. The model is contractarian, one of contract. You come and we have a deal. I am giving you this resource to exploit. And as you're exploiting it, we share the profits. Typically, when people set up businesses, they don't collect royalties. When people set up businesses and they allow third parties to come in per participation, they don't collect royalties. So the question as to why Ghana seems to like the model of royalties has been surprising. I will argue that royalties are a thing of the colonial legacy. When the colonial man came here, saw the country, colonized us, and the reality came and they had to hand over and leave, the model was, we'll hand over and leave, but we'll not leave the resources. And how do we keep the resources? We keep the resources by dangling incompetence in the faces of those who apparently own it. You own the thing, but what use is gold when it's in the ground? Until you bring it up, it is not gold. I'm going to help you bring it up. You do nothing. Just stay home. You do nothing. All you have to do is just remember that the month has ended or the year has ended. And then I'll give you a percentage. You do nothing. You invest nothing. You have zero risk. And I'll give you a percentage. And we seem to accept that because it's a very lazy, very comfortable way of doing nothing but somehow having a small percentage of nothing, of something which is better than nothing. We have gone as far as to extend the royalty model to the extraction of oil. And that has become the model, and it has become contested under some circumstances, creating even issues involving not just the exploitation itself, but the payment of other statutory obligations while operating in town. Perhaps the time has come when we should move away from royalties to ownership of the resource. But the ownership of the resource invariably can still be done using the model of the royalties, except that we are not taking royalties, but we are participating in the sharing of the resource. As I indicated, this has been done elsewhere. And I think the fear that once we move away from royalties and we start demanding and asserting more, people will be angry, or rather investors will be angry, they won't come to your country, they'll go elsewhere, which is the model, the standard approach investors have adopted over the years. And they will be worried what happens to the gold. If they are not coming, the gold will get wasted down there. The truth of the matter is, as we all know, it has never happened anywhere. The investor threats to go elsewhere and not follow your resource, it's been said in many places, but it has never happened anywhere. They will still come. We need to have the confidence and the tenacity of purpose to believe in the fact that these resources are needed. And as much as they're needed, the one who needs them will come for them. Of course, the negotiations can get tough, but invariably we would end up agreeing on something which is better than the current model. How we go around these, I am not saying it's going to be easy, because we all know the realities. The realities are that there are embassies, and when the introduction was being made, I think we know that there's 1 or 2 embassies here. There are embassies, and embassies represent national interest. And we know that when some investors are likely to be touched in some of these recalibration of resource rights, I know for a fact that there will be phone calls, that there will be quiet diplomatic meetings, there will be pressure, there will be expressions of concern, there will be all kinds of pressures out there for countries to tone down and to stay with the status quo. But the truth of the matter is that if we want to become a Botswana, we can't become a Botswana by going by the current model. It simply is not working. The current model favors the investor, and the owner of the resort, which is the home state, have for over the years perennially just been receiving pittance, which hasn't been contributing to our national development. Another difficulty with our current model, the current mining right model, has to do with the issue of transparency. I think one of the biggest challenges that we've had, and this is something again we can't be mute about, has to do with the issue or the issuances of licenses. We've had licenses issued in places. Apparently, some of the people who are mining near our river bodies, and these days inside our river bodies, actually have licenses. And if this is true, then it remains, the question remains, and we would have to have answers. Once again, my very good friend, Mr. Hukofu, is here. I don't know to what extent the Environmental Protection Agency, for example, which you headed, might have been involved by way of consultation in the issuance of some of these licenses, i.e. projects that are so proximate in location to water bodies, and in these days, some of them inside the water bodies. If anyone is mining inside a water body, and the person has a license, that is a criminal conspiracy of the state against itself. If anyone is mining near a water body or inside a water body without licenses, then that person is the criminal, for which reason we can't even negotiate. We can't negotiate with criminals. We've gotten to a point where resource owners must begin asking fundamental questions. And Ghanaians, being the resource owners managed by the president on behalf of the people of Ghana, the truth has to still be spoken and asked. To what extent are the issuance of licenses done in a transparent manner, particularly given some of the challenges that we have experienced with people who are mining in water bodies and who are mining in places that are destroying our natural resources. So transparency is key. In other jurisdictions, Botswana is an example. In other jurisdictions, you actually have public participation in the issuance process. And so, for example, perhaps the time has come where all license applications must not only go through an environmental impact assessment that I know the EPA conducts and undertakes public hearings, but perhaps the Minerals Commission must itself undertake public hearings with the radio stations and the TV stations all there. We must know who is applying for which license and whether or not the Minerals Commission is disposed to grant it, and then whether or not anybody in the public space has an objection to such minerals and mineral rights being applied for. Because unfortunately, time was when we could all just imagine that the Galamsey menace, for example, is so far removed from us. It's in a certain village and a certain far-off part of the country. We can only hope and pray it doesn't get close to us. I think the truth of the matter is nearly all of us here, I am sure, have contemplated undertaking backyard gardening. And the reason for that is Galamsey. The reason is suddenly when I'm eating fish, I reflect in ways I have never reflected in the past. Because the fish might just be coming from a river which is infested, which is deeply polluted by heavy minerals, and this fish has swallowed things that is in the fish's body, and I'm just eating it, and I can't dissect it. In fact, I do dissect it. You open it up to check if there's anything embedded in there. But how much can you do? The truth of the matter is, unfortunately, we are all so endangered that unfortunately we do not, or we cannot compromise on some of these conversations anymore moving forward. I promised you I'm going to make it short in the beginning, so I'm going to run through very quickly just to wrap up because there will be a discussion so we can have the conversation. But as we move forward with our minerals and mining law reform, particularly for mineral rights, there has been proposals in the current reform that is ongoing that we should have a duration on the license, the issuance of licenses. The licenses should have shorter durations and not longer ones. With the greatest respect, I would like to propose that we should think very carefully about this. Because I think that while it sounds funky and fancy on the face of it, that when you limit the duration, you tend to control it better. I would argue that it will actually have a counter effect if care is not taken. And this is the reason why. When the duration for licenses are limited, what happens is you rather create the rent incentive for the license issuance anytime there has to be a license issuance. And so I'll give you an example. If you issue a license for, say, 4 years, and the license expires, the new license that has to be issued, if, for example, there was government X, which was in office when the license was issued, and now there's government Y in office when the license is expired and a new license has to be issued, the investor will go through the rent-seeking problem, which is very often the situation in Ghana when anybody is seeking any license of a certain size, of a certain standing, and of a certain interest. You know, people have to see people or want to see people, the usual things. The usual things that we often deny in public, but we all admit in private, and that is corruption. I think that making the license duration short might aggravate the rent-seeking scenario. Is there an answer to this? I really honestly haven't come out with a solution, but it's something that we'll have to be thinking about as we are thinking of reforms. Perhaps we may want to deepen again the structures of transparency. Where there is no transparency, you have rent-seeking. It's simple. Where there's no transparency, people's authority and powers are aggravated, and when they have the opportunity, therefore, to benefit from the power that is given them. But the key one is one that I've already mentioned earlier, which I'll reiterate again, and that has to do with the state participation. Is it time that Ghana considers becoming a participant in mining projects instead of becoming a royalty recipient or a recipient of royalties? Is it time that Ghana becomes a shareholder in companies? The truth of the matter is that it will not make Ghana as attractive as it used to be. But would it make Ghana a deserted place? I guarantee you it won't. Because those resources are there. And the people who mine them will continue needing to mine them. They will simply have to push the boundaries of their interest as far as they can to see to what extent would you push back. If we do push back strongly, the minimum we can get in the end is to get a bigger concession that we currently have. Currently, the concession is just not good enough. So maybe it's about time that Ghana becomes a beneficiary. Ghana considers not just being a recipient of royalties, but actually a front burner beneficiary or a country, taking the model of Botswana. If, on the other hand, as a country, we remember how very poor we can be in managing our state resources, we shouldn't forget the fact that our SOEs are around, and they have not been particularly the best managed. Our SOEs have continued to post losses over the years, and in the last 3, 4, 5 years, they posted some very big losses that have become matters of national concern and discussion. And so somebody would ask, do we really want to add this to our problems and go and take private mining companies and let government manage them? Because we all know what happens. Government managing them means that they appoint the MDs, or they may control the MD. They may have controlling interest and appoint the board, appoint the MDs, and typically the rent-seeking and the politics once again takes control of that. But government can choose not to be part of management, but to be part of the profits. What is of interest here is the profits. If we can leave it in the hands of private management, the investor can take full control of everyone, from the board to everybody, everything else. But for the shareholding, Ghana is interested. So that whatever profits these companies are making, Ghana becomes a beneficiary. As I indicated, this is not going to be a comfortable conversation, because it's important to remember that there is a political economy surrounding this. And the political economy is one that involves very heavyweight investor interest, often outside the shores of this country, often controlled through embassies. And it's not easy to just change things the way they are. But once other countries have done them, it is a statement of what is possible. And it's up to us to decide to start exploring that, particularly as we may be at the intersection of law reform in the area of the minings and mineral laws of Ghana. The next point I would have to make here, penultimate point, is the issue of local participation or local benefit. History has it that Johannesburg and Abotsi started off as towns around the same time, sometime around the 1890s, when Johannesburg and Abotsi both started off in terms of gold mining. So Abotsi and Johannesburg, I think 2 years interval between them, Abotsi and Johannesburg have a lot of history together. Interestingly, Anglo Gold Ashanti is an Ashanti Johannesburg, or rather Abotsi Johannesburg oriented companies. Anglo Gold starting from Johannesburg, Ashanti from Abotsi. But we all know the story. The two of them stand as examples of how local benefits of resources can build cities or towns and how they can deplete them. While Ashanti stands on the extreme end of the spectrum in terms of how local resources can be a bane or the Dutch disease, Johannesburg stands on the extreme end of the prosperity scale of how gold can make you. In fact, I have seen pictures of the two before where they were almost identical in some ways, almost identical in terms of being rural, being regular, being nothing, essentially. And we all know the story of Johannesburg today. A very developed part of Africa, some would say perhaps the skyscraping capital of Africa. On the other end, we also all know how Abotsi looks like today. These two towns illustrate to us how owners of the resource should become beneficiaries of the resource. If Ghanaians own the gold in the land, the local people are the first owners. And then the generality of the country should be the secondary owners. It is important for us to remember that when the local people suffer from the effects or the consequences of the pollution, from the effect or the consequences of the devastation of farmlands, from the effect or the consequences of migration of the youth to the cities because the place has become desolate, the people who suffer the first are the local people, not those of us in Accra. Can we therefore have a justification why the people who are at the base of the resource should have the same treatment as everybody else across the country? I think there's a logical case that the owners of the resource, the initial people who sit on the resource, should have a greater claim to the cake or the pie that is being shared from that resource. It is on that basis that I'll say that I support the proposal that has been made in terms of the new law reform that is ongoing, that we should have a greater stake of local content, of the people who are actually members of the community of the place where the resource is. And then, of course, we as a country can generally have the bigger pie shared together or across the country, so to speak. But the idea that we have been following the old model, it's for everybody. You know, once they discover it, as soon as the thing is discovered, you've lost it. It's for the entire country. Everybody gets the same thing. I think it's unsustainable, and it's something that we would like to have to look at. You ask anybody from Takoradi, and they'll tell you that one of the spillover effects of the discovery of oil in Takoradi is the fact that rent in Takoradi was unacceptably high. And therefore, you can well imagine the people who lived in Takoradi, how they were suffering to pay rent. And so, somehow, we were in Accra and getting the same, we were taking everything and sharing it equally among ourselves. So that somebody who lives in my village, which I won't mention, but who's probably not paying as much rent, that somebody is getting the same, ultimate benefit from the resource as the person who lives in Takoradi and immediately is paying a price for a resource that has been discovered offshore, but nonetheless very close to Takoradi in proximity. So it's important, finally, as I'll say, as I take my seat, it's important for us to remember two things. The first one being the unsustainable exploitation of resources. The fact that, unfortunately, we cannot continue in this debate of whether or not people who are destroying our environment, whether or not they should even have any right at all. The people destroying our environment are destroying a resource, not something which cannot be considered as a resource. It's a resource in its own right. So what we have is the people destroying the environment considering one resource as more important on the basis of market demand. So it's a simple case of market demand. Once there's a greater market demand for it, the one which is of less market demand, not because the market doesn't demand it, but because the price is not there. And because the price is not there, they would rather destroy the one with the less price in favor of the one with more price, regardless of the issue of how important they are. I think we'll all agree that water is more important than gold. But unfortunately, people, if you say that, the first question the gold miner will ask you is, how much do you sell a gallon of water, and how much do you sell an ounce of gold? These are considerations that, unfortunately, tends to blur things in the minds of people. And I would say to those people, they do not understand. Perhaps they haven't even read the Midas story. The Midas story, I wish everybody reflects on that. That very soon, we can't eat gold. Very soon. We are not even reflecting on that. Perhaps when we all become super rich, we can all go and have lunch in France and come back to Ghana and go have dinner somewhere in Spain because we have destroyed Ghana, but we have enough money to travel around the place. So it's imperative that we have a stringent regulation of the mining dynamics of small-scale miners. The proposal that has been made to have a medium-scale mining right, I think is an interesting one, and it's one that I would also urge should be carefully looked at. However, the parameters of that mining license is one that needs to be looked at. The issue may not necessarily be the duration, the issue may not be the size of the concession, but the issue may be the extent to which sustainable mining practices will be adopted in any such medium mining license. We have had smaller scale miners, and they are always ready very quickly to distinguish themselves from, quote and unquote, the Galamsey people. So how do we resolve the Galamsey debacle or the Galamsey problem in favor of small scale miners through this medium mining license that is being proposed without compromising on the standards of mining? I think with Galamsey, the worry we've all had is about the standard of mining. People have been worried about how we just are depleting the resource, especially backed by some heavy financiers, foreign interests, and other faceless people, so to speak. So that's the first part in my conclusion. The second part in my conclusion, or concluding statement, is that as we protect the investor, so should we protect the owner. Traditionally, the owner has been laid back. The owner has sat back and then just accepted royalties. These royalties, as we all know, given the benefits that these investors tend to have, these royalties have not gone as far as they should go, given the expectation of how these mining and mineral rights are intended to protect the commercial interest and expectations of Ghanaians. I think it's about time, perhaps, that Ghana adopts a more proactive, but rather commercially active interest in the management of these mining concerns. And the best model or approach, as we've indicated, may not necessarily be to participate in the management of these companies, but rather to take equity interests in these entities so that the commercial gains that come as windfall in these companies, Ghana as a country can also benefit from that. Finally and fundamentally, transparency, as I've already mentioned, is an important word and would have to deepen transparency in the new law that is probably intended to be laid before Parliament. No act can be successful in terms of protecting mining rights or other mineral rights of Ghanaians without transparency. And the reason is simple. The access to these resources is granted through concessions. And these concessions are granted through licenses or a licensing regime. The licensing regime is fundamentally where the difference is. Many of these companies, if you complain against them, or these entities or people, if you complain against them, the first reaction will be to let you know they have licenses. So they have the license to do what they're doing. And if anyone has a license, you can't prosecute them. You can't take them on. So the source of the problem appears, therefore, to be the license. Until we deal with the transparency of the process, the right regime will not succeed. And so transparency represents a fundamental source of curing a long-standing problem. And as we undertake all these reforms, I would urge that we deepen the strictures and the structures of transparency, as that could be the source to identifying many of the other challenges. My lady, Madam Chair, thank you very much.